Sometimes we get asked, hey, the other driver was intoxicated. Am I automatically entitled to damages? The answer to that question is that in every case, you have to prove the level of harm that you suffered as a result of an accident or an injury or an event. So even though another driver may be intoxicated, you still have to prove how did that intoxication crash result in harm to you. The fact that a driver may be intoxicated may make it easier to prove that that driver was negligent. In other words, that that driver failed to use ordinary care, failed to follow the rules of the road that we expect all drivers to follow. But you still need to show what the harm is and how that harm has resulted in a money, damage, loss, or interruption of your life. One other interesting thing to know about intoxication cases is that sometimes there are insurance exclusions that certain insurance policies won't cover or will limit the amount of coverage for an intoxicated driver. So it helps to have a lawyer who is asking those questions, familiar with those insurance policies, and it helps to have somebody who will look at all the available insurance coverages out there, including your own insurance coverage. And then finally, another very important thing about intoxication cases is there is the possibility of recovering what's called punitive or exemplary damages. Those are damages that are meant to punish the wrongdoer for conduct that is deemed outside the bounds of acceptable society. And then one other thing that probably bears mentioning is your lawyer, even if it's an injury lawyer, ought to be following the prosecution of the drunk driver, because as society, we need to make sure that drunk drivers are prosecuted. And if you hire a lawyer to handle your injury case, it sure would be nice if that lawyer is working with the prosecutor as well to make sure that as much as possible is being done to ensure that justice is served in your case.